This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
BPS, how are you?
I'm well, Mark. How are you?
Good. I don't think I've been in the same room with you, and I don't know how long. It's been a virtual relationship for the last couple of weeks.
It's been, several weeks, I think.
Yeah. You good? Wearing your Trojans shirt? What occasion this?
No occasion. I was around the house today, and this is usually for football games, but just what I grabbed and threw on first thing this morning. I didn't even realize I was wearing it until you pointed it out.
I was going to say it's usually you reserve this for football season, unless you're a junior varsity fan. I don't know what the. This is traditionally a football season type of thing, but it's also a. When you're hanging around the house, you don't really care which t-shirt you throw on. So this was what was clean, and there we are. Here we are. Okay, got it. What's the what's the story that is intriguing you this week? If I were to let you curate,
I mean, I think you might get in trouble with a specific judge if I was to curate the most popular story. But beyond that, I think certainly the defense taking over on Karen Reed is interesting. What? So
tell me about that. Because, I think I commented before. It's amazing to me. Harvey Weinstein is on trial. Isn't that wild?
It's hard to believe that it's getting absolutely zero coverage outside of your other podcast.
Right. And the Karen Reed case, which was really kind of wall to wall, has evaporated.
Yeah, it has. It seems the media coverage has slowed quite a bit. Even, the online coverage, there are still a few people out there who are covering it, but everything's been subsumed by the case that the household you're sitting in is most consumed with. So, Karen Reed, I think the prosecution rested and turned it over to the defense, and the defense is now putting up their witnesses. I believe they tried before they took over the case to get a dismissal based on the fact that the prosecution, in their eyes, did not establish that a collision had occurred. I believe that was Alan Jackson's tactic. That was not granted, so the judge gave it to the defense.
Shock that judge did not grant that motion.
I love how media outlets cover things that are procedural and standard for every trial as though they're news. He requested a mistrial. Like, okay, yeah, obviously, but there were headlines about it.
Right, and they shocked the judge didn't grant it. What did you think as a layperson? Although, albeit you're more well-versed in the law than most lawyers I know. What did you think about the way that the prosecution ended their case in Karen Reed? Are you aware of this playing of the snippet from the documentary where she said, I might have hit him?
To me, I can understand why that was the decision that they made and why that game plan probably looked good at the beginning of the trial. They had their whole timeline of what they wanted to do laid out. In my opinion, given what the defense was able to do to some of their witnesses, particularly their experts, and we've talked ad nauseum about the gentleman who has been trying to get a bachelor's degree for 17 years and has so far been unsuccessful. I thought that I don't think it resonated as well as it could have had their case gone better and had the defense not had so much success throughout them presenting their case. That's just my opinion.
And by the way, it did, my view on this as somebody who's tried a couple of cases, it almost reminded me of somebody who was writing a script for a bad episode of Suits, who thought that Harvey was this is what I'm going to close my case with, is her saying, and by the way, if I'm the defense in closing, I'm going to play that clip again, and I'm going to tell the jury, this is the best they've got. her saying maybe, coulda, I racked my brains. Well, of course she's racking her brains. She's being tried. They're coming at her. They're trying to take her down. And she's trying to think of every potential possibility. And that's what she's talking about at the time. And they think that's some kind of gotcha moment. If anything, I think it establishes the fact that she's not guilty. It doesn't establish, to my mind, anything else. It's not an admission. It's not a confession. All it is her saying, I was here, I'm in the crosshairs. Obviously, I'm going to think of every single permutation. What am I going to do? Just go into a hole or like an ostrich sticking my head in and ignore what the possibilities are because the prosecution is coming after me, guns blazing.
Yeah, absolutely. I mean, I think it is reason. I agree with your assessment, although it seems like more of a Louis Litt play to me. But but you know, if I'm on trial for or in the crosshairs for a murder, and you know my boyfriend is dead, of course I think I would be thinking through every single possible permutation of what could have possibly happened because my life literally depends on it. I need, you know, if I don't know what happened and I'm being told that this is the theory that they're operating under, of course a smart, you know, person, which by all accounts Karen Reed is a, you know, above average intelligence, you know, citizen of the country, you know, she's going to be thinking, okay, they say I hit him. Did I hit him? Could I have hit him? I mean, that's kind of what the clip is. It's just sort of her considering the operating theory of the case and sort of speaking out loud about, you know, what the different possibilities are. I don't think it's as damning as they think that it is, or that
I think it's quite the opposite. I don't think it's damning at all. If anything, it shows that she is addressing it. She's confronting the evidence. She's thinking about the evidence. By the way, that's what you're supposed to do. They have the burden of proof. You're supposed to stick yourself in their shoes, understand what their theory is, and then try to deal with it. I mean, like I say, it's a very bad script in a very bad episode. Touche. Probably was more Louis Litt. Apologies to Harvey.
Well, you know, it's just as someone who's rewatching that show at the moment, it's all very top of mind for me. So that was why I had that reference ready. But yeah, the whole thing is, you know, the whole trial it is like it's written as a bad episode of television, in so much that you can't understand why this is even happening. And then at every turn, it's the prosecution thinking that they've laid out this perfectly crafted script, only to have the defense come in and go, what are you talking about? Do you know what you just said? And getting eviscerated. So
I know. I just don't get it. I really don't get it. I don't understand what they think. I sent you a couple of clips this week. One was, people often ask me, there was one particular clip. Early on in my career, I did a lot of DUI defense work, and I always wondered why there wasn't more camera involvement back in the 80s and the 90s in terms of DUIs. And then I saw this clip, and I sent it to you, of a woman and the cops, and obviously there's other intriguing aspects to it, but I thought it was helpful in terms of, from the cop standpoint and from the lawyer standpoint, when you're talking to the client, really, do you want me to show this to a jury, or do you think maybe we should find you a soft place to land?
Yeah, you're talking about the AI-based reenactments?
No, I don't think so. I will go to that in a sec. This was a woman who was pulled over, presumably for DUI. Did I not send this to you?
It's not ringing a bell.
Okay. Well, then let's do the other one that I said that I was just, I think I put it on a chain with you, and if I didn't, I have a separate chain with somebody else. Can you set this up? Because if this isn't in your wheelhouse, and if you wouldn't have immediately understood what the import of this is, I don't know you.
Yeah. So this is a video of, victim impact statements, right? Which are typically text-based. And now there are jurisdictions where people are experimenting with having them recreated as though they are being read by real people, when in reality it's just an AI recreation of the statements. And presumably, because it appears at least like they are being read by real people, the hope is that they will carry more weight than they would have if they were just being read aloud in a courtroom. So I can play you a little snippet of it here, and you can call your own out, because I don't know that we necessarily need to play the whole video, but let me share it with you here, and then we'll play a little touch of it.
Hello. Just to be clear for everyone seeing this, I am a version of Chris Pelkey recreated through AI that uses my picture and my voice profile. I was able to be digitally regenerated to share with you today. But here is insight into who I actually was in real life. Take a look.
All right, I'm Chris Pelkey. I served with the United States Army in the infantry. I'm from upstate New York. And what else?
Where'd you deploy?
Where'd I deploy? I went to Baghdad in 2006, 2008, and then I went to Afghanistan in 09 to 10. I think the number one thing is God, is having a relationship with the Lord and being close with Him, and
go
He
back
really is the
to
only answer
the
to every problem we
earlier
have.
the spot, Gary. See that, so the people who are watching it now, that is the AI created. Now, I have no qualm with the other portion if that was not AI, if that was an interview and they wanted to show a clip for sentencing purposes. I get it. One of the toughest things if you're defending a criminal client who is, and you're sentencing, victim impact statements are where the victim gets up and it's basically a statement, as it's called, that lays out exactly the impact of the crime upon the victim and the extended family. Obviously, if the victim's not there, can't articulate how it impacted them because they're deceased. It's the ripple effect through, and I get that. But the idea of you're now going to recreate an AI voice of the deceased, and I believe the lawyer, and I hate second guessing lawyers, as you know, but I think he said he thought it was cringe. Is that the term that was used?
Yeah.
And I agree. And the first thing he should have done is said, objection, this is improper, because you should not be allowed to tug on the heartstrings. And I believe the sentence ultimately was more than what would have been expected. So it's hard to quantify what happened, but I will tell you that there should have been an objection and there should be a fight against that being admissible at a victim impasse. I understand the clips of the person when they're alive. I think that's fair game, but I think this is something that is not just a slippery slope. I don't even think you can open the door to it for this particular purpose. I understand it for simulations. I understand it for recreations or reconstructions, but not in this case.
Yeah, I agree. I mean, it is, even if it is a statement that someone gave in the past, it's akin to putting words in someone's mouth to give the AI the power to convey emotion that may not have been there when the statement was given, or to, give tells visually about, how the person feels about it when that was not actually in the statement to begin with. Seems like a very slippery slope.
Yeah, I would imagine somebody's going to have an appellate field day with that.
I would think so.
If not there, somewhere else, I think as well. There's been some other court cases. I think Brett, our fearless researcher, had one court case that he mentioned that I wanted to wrap up with, if I could.
Yeah, this was the case. Which one? I'm sorry, I'm forgetting here.
Yeah, I think it was a SCOTUS case that Brett had.
Yeah. Sorry, I'm trying to pull it up here in the background. Let's see here.
So there's been a wealth of cases that have either been taken, argued, or decided in the U.S. Supreme Court. The calendar does not appear to me, at least, I haven't done the quick numbers, to be markedly busier than usual. In fact, some would make the argument that, at least in a historical context, it's actually lighter than usual. But for some reason, it seems that there is a wealth of consequential cases on a more regular basis for a kind of a period of time that appears to be regular or more systematically regular. And some interesting dynamics in terms of the votes. You now have people, you and I have talked about the 333, and that I really think has started to solidify, and at a certain point, I think it's morphing a little bit into a 5-4 or a 3-2. 3-2-4 kind of a split. And what I'm talking about is Amy Coney Barrett seems to be shifting a little bit in terms of the decisions that are being made. Kavanaugh and Roberts still being the two, and obviously Alito, Gorsuch, and Thomas as the rock grip three is the kind of gross oversimplification that I like to say, because obviously when you do that kind of analysis, you don't really take into account the various kind of the issue-based or the kind of ideological bent that the individuals have. I always think of Gorsuch that way because, as you know, I think a lot of his analysis and some of these opinions. And while he does tend to, I think, if you were to do the numbers, have an affinity for the group that is Alito and Thomas, he moves across that spectrum, I think, with depending on the issue, with a lot more fluidity.
Yeah, I think he absolutely does. And I found that case that you were referring to from our fearless associate, Brett. That one was concerning the 37-page memo that the Milwaukee County judge has filed, citing that she has immunity, is what she's arguing. This was the judge who was arrested for attempting to prevent federal agents from arresting someone who was in her courtroom.
So I haven't read it yet, but it struck me because we talked a number of episodes back that I thought that that's where they were headed, judicial immunity. And if you call it up, or maybe I'll do it before next week since we don't have that much time left, my guess is that Morales versus Waco is going to be in that. And I'll read it and take a look, because that is, to my mind, the judicial immunity last real pronouncement by SCOTUS that would seem to apply in this situation. And I expected, and now we've seen where they have filed this, and I think that's going to be squarely where they're going to deal with it. I'll do a little analysis before next week because I think it's a fascinating issue.
Yeah, absolutely. I think that we should definitely touch on it, and I think that would be great to do next week.
But did you pick a comment? Don't tell me you didn't look at them. There were a couple of very, very good comments, and one person complaining they hadn't gotten their merch.
Yeah, I saw that, but I don't know how to verify that because there were more than one, and I have not. While it's possible I missed somebody, that's a pretty clever way to get yourself some merch too. So I don't. If you in fact claim you have not received your merch and can verify it, please send me a note at reasonabledoubtpodcast1942@gmail.com and I'll get you squared away. But you got to send in the evidence as well, because I can't just take a YouTube comment and take that as Bible.
Receipts.
Yeah, I want the receipts. Absolutely.
Okay. Now pick one, Gary. I'm going to let you pick. I know you claim you don't read it, but so read it on the fly. Right. Pick your favorite, because you actually kind of invited the comments last time with the, they didn't have to be as snarky about you. I would disagree with your characterization. You're going to push back on that?
Yeah, I am. I do think I have I have in fact found, I think, the video that you were referencing earlier of the DUI arrest. But if you want me to pick,
let's go back to that. Let's go back to that while you're looking for comments.
All right. Well, I'm going to have to play that just straight off of YouTube here because I do not have the time to download it, but we'll go ahead and share this screen and we can play it. Let's see here. Is this in fact the video you were thinking of? This one right here?
No, but let's play it anyway.
What are you arresting me for? Don't elbow me in the...
Oh, this isn't the one I was thinking of either.
Okay, let go so I don't break your finger.
Do it.
Stop.
Do it.
This is a weird compilation, so let's skip that. Let me go ahead and...
Maybe we'll do next week's show as a compilation show because there's so many with the new kind of the FOIA request, the cleverness on the internet. I think it's a compilation of these would be very entertaining, if not informational, depending on what you should or shouldn't say or what you should or shouldn't do.
This is pretty funny. When Gary doesn't send swag and there's a musical note, it says, you fight on, you fight on. When Gary is doing you wrong, you fight on. And then there's another musical note. That one comes from Mark T. .3215. That's pretty funny in a reference to the. And
by the way, wearing the Trojans shirt, I think that's a winner.
Yeah, there you go. So Mark T, reach out.
Mark T. You got it. Mark G to Mark T. You got it.
All right, Mark, thank you so much for making some time for us. And we will see you. Maybe I'll see you in real life sometime in the near future, too. But if not, we will see you virtually next week.
Thanks, Gary. Good to see you. Thank you. Have a great evening.
Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.